To really know the contours of a legal right, you need to know not only the substantive content of the right, but also you need to know how the right is protected. In an immensely important article, Guido Calabresi, now a judge on the Second Circuit of the United States Court of Appeals, and Doug Melamed, who was a former head of the Justice Department's Antitrust Division, they pointed out that legal entitlements tend to be protected in one of two distinctive ways. Some entitlements are produced by strong property rules, which attempt to deter third parties from non-consensually taking the entitlement. Property rule protections are punitive in nature, often involving the threat of jail or supercompensatory punitive fines. In contrast, other entitlements are protected by weaker liability rules, which attempt to compensate an entitlement holder for the loss of an entitlement that is non-consensually taken. The rules are concerned with two different groups. Property rules are designed for deterrence of potential takers. Liability rules are designed for compensation of potential takees. So a first task is that whenever you learn a new legal right, is to ask yourself, how is that right protected? Liability and property rules were given their names because the law of property tends to protect property rights with property rule protections, while the law of torts tend to provide liability rule protections. But what makes this task more difficult is that most areas of law, including property and tort law, have deployed mixtures of property and liability rules with regard to particular legal entitlements. Sometimes the extent of protection will turn on who is doing the taking. Your home is protected by a property rule, criminal trespass, with regard to taking by a private citizen, but only a liability rule, that is the Constitution's takings clause guarantee of just compensation, with regard to taking by the government. Sometimes the extent of property protection turns on how the taking occurred. If you intentionally take my car, then the criminal law sends you to jail. But if you negligently destroy my car, the law of torts says that you merely have to compensate me. Calabresi and Melamed went on to suggest that property rule protections were likely to be more efficient when transaction costs were low, and that liability rules were more likely to be efficient when transaction costs were high. If the parties can easily contract, agree to consensually transfer an entitlement, the law is likely to and should protect the entitlement with a strong property rule to induce the parties to expressly contract. The law is more likely to use liability rules when the parties don't have an opportunity to contract. For example, in the tort setting where it would be infeasible to contract with the myriad of drivers who might hit your car. Or consider the case of a dock owner who has the entitlement to exclusively use her dock. Under normal circumstances, where the third parties have an opportunity to bargain to rent dock use, the entitlement is protected by a property rule. But the tort doctrine of necessity says that under unusual exigencies of a severe storm, where third parties may not have the opportunity to contract, a ship owner can use your dock without your consent and only have to pay you reasonable compensation. This type of liability rule protection gives a new meaning to the phrase, any port in a storm. This transaction cost theory says that property rules force takers to use market contracts when they can, and liability rules allow takers to mimic the market when the takers can't use the market. When transaction costs are low, the threat of property rule punishment channels potential takers to consensual takings, that is, to contracts. When transaction costs are high, potential takers can emulate the results of contracting by taking non-consensually, docking during a storm, and then paying the compensation that might have been paid if the parties had had a chance to contract. A second task when you learn about a new legal right is to ask whether the law offers the right kind of protection. After you figure out how the legal right is protected, you should also ask yourself whether it should be protected by a property or a liability rule. One way to approach this normative inquiry is to follow Calabresi and Melamed and to ask whether the parties had a sufficient opportunity to contract. If yes, the Cathedral article of Calabresi and Melamed would suggest that the property protection is more appropriate. Pop quiz. Is the takings clause consistent with Calabresi and Melamed? Curiously, however, Calabresi and Melamed, who surveyed vast portions of law, did not analyze how contractual entitlements should be protected. And we should forward it here. What about contractual rights? If Calabresi contracts to sing at Melamed's wedding, Melamed has a contractual entitlement to Calabresi's performance. How should Melamed's contractual right be protected? Calabresi and Melamed's theory might suggest that contractual entitlement should be protected by property rules, such as court orders of specific performance, perform or go to jail. After all, the parties were able to contract initially. Calabresi should be able to renegotiate if he doesn't want to perform. The singing Calabresi could buy back Melamed's contractual entitlement to hear Calabresi sing. But contractual law normally does not protect contractual entitlements with specific performance. It doesn't normally use property protections. Instead, the normal remedy is a liability rule protection, which is expectation damages, which just try to compensate the non-breaching party. Still, there are several instances where contractual entitlements are protected by property rules. For example, in Jacob and Youngs versus Kent, the cost of replacement measure would have given future sellers strong incentives to perform. More generally, the cost of performance measure, which measures expectation damages by how much the promisor would have to pay to perform the promise, will tend to deter the promisor from breaching. Why breach if it doesn't save you any money? The tool of classifying legal rules as being protected by liability or property protections can be deployed in any legal subject, even constitutional law. The Constitution ordains that every state shall give full faith and credit to the public acts and records of every other state. But how should this entitlement be protected? Might a sibling state choose not to give credit to the public act of another state and merely pay liability rule damages? Does the Constitution always demand property rule protection? The take-home lesson is that when you learn about legal rights and entitlements, you should ask how the right is protected by learning the consequences of various types, intentional versus negligent, of various types of takings by various types of people, public versus private actors. You don't really know the value of an entitlement until you know how it's protected. Hold on to your hard drives. Today's lecture is one of the hardest and most esoteric concepts that I'll be talking about in these lectures. It's not for the faint of heart. Yale Law School professor Wesley Newcomb Hofeld, before dying at the tender age of 39, developed a new field of analytic jurisprudence in the 1910s with the publication of 2 articles that set out a framework that sought to capture the fundamental elements of legal relations. In this introduction to Hofeld's theory, I'll be focusing on the distinction between a Hofeldian right and a Hofeldian privilege. This distinction is captured in the following table. To demystify this non-intuitive framing, let me turn to an extended description by Duke professor Madeline Morris from her article, The Structure of Legal Entitlements. And this is quoting her article. We can use the example of a parking garage to work through this distinction. The parking garage in my office building sells both general and reserved space monthly parking passes. A general pass allows its holder to enter the garage, search for a parking space, and park in it unless the garage is full, in which case the general pass holder will have to wait for a space. The reserved space pass, by contrast, allows its holder to park in a particular parking space and prohibits all others from parking in that space. Suppose that I like to park in parking space X because it's closest to my office. If I have a reserved space pass to park in space X, then I have a Hofeldian right to that space. You have a corresponding duty not to park in that space. If, on the other hand, I have a general monthly parking pass, then I have a Hofeldian privilege to park in space X. I may park in space X if it is empty, but I'm not guaranteed access to it when I arrive. You may have already parked in space X, since you have no duty to refrain from and indeed have the privilege of parking there. Thus, when I have a Hofeldian right, I have a right to enjoy the object of that entitlement, parking in space X, in a way that involves your having a corresponding duty, your duty not to park in parking space X. By contrast, when I have a Hofeldian privilege, I have the privilege to enjoy or attempt to enjoy the object of that entitlement, parking in space X, but without your having a corresponding duty. You have no duty to refrain from parking in that space. Hofeld notes that a duty is the opposite of a privilege. Your duty not to park in space X is the opposite of a privilege to park in the space. Hence, the absence of a privilege to park there constitutes the presence of a duty not to park there. And conversely, the absence of a duty not to park there constitutes the presence of a privilege to park there. Therefore, my having a Hofeldian right to park in my reserved space X means that you have no corresponding privilege to park in that space, while my having a Hofeldian privilege to park in that space would mean that you do have a corresponding privilege to park there. The difference between Hofeldian rights and privileges thus turns on whether the other party holds a privilege. If the other party has a privilege, then I possess only a privilege. If the other party has no privilege, but rather a duty, then what I have is a right. Unquote. For Hofeld, what would voting be, a right or a privilege? Who would be subject to its jural correlative? Exit and voice are the terms used to represent the two core ways of protecting associational rights, especially minority rights. The concepts were made famous in a book published in 1970 by Albert O. Hirschman entitled Exit, Voice, and Loyalty: Responses to Decline in Firms, Organization, and States. People who choose to associate with a particular group can protect themselves by leaving the group or by complaining. The former is called exit, the latter is called voice. Imagine you just finished an absolutely awful meal at a new restaurant in your town. What do? Say something to the server or manager, leave a low tip, or vow never to patronize the restaurant again? The last option, which is the most frequent response, is an example of exit. The law can and does at times require association to give its members exit rights, and sometimes it requires them to give them voice rights. But the extent of these rights vary with particular contexts. For example, John Morley has shown that mutual funds provide strong exit rights, but very ineffective voice rights. If you don't like the way your stock mutual fund is being managed, you're free to sell your investment. Similarly, people who borrow money to buy a home now have stronger exit rights because prepayment penalties are now prohibited. In contrast, minority shareholders in certain close corporations have limited exit rights, but more generous voice rights to speak their mind if they are represented on the board of directors. Both voice and exit can have a disciplining, even a deterrence effect against certain types of opportunism by those in charge of the association. Voice can mean not only communicating with those in control to try to persuade them to change their policies, but it can also communicate to other stakeholders and to try to persuade them to vote with you or exit by stop associating. Charles Thibault model of local government is a classic example of the disciplining power of potential exit. Thibault imagined in a world with a large number of city organizers or entrepreneurs who each announce for their particular city a system of taxation and available amenities that their city will provide. The prospective residents of these competing cities have no right to vote or to complain. They simply vote with their feet, gravitating towards cities with the appropriate mix of taxes and amenities. The assumption of free entry and exit in the absence of voice rights is sufficient in the Thibault model to produce efficiency, fancy talk for the kinds of cities that people want. School choice, including school voucher programs, is a way to expand rights, exit rights and entry rights instead of relying solely on voice rights, things like the PTA, in the more traditional system where students had to attend their local school. For discussion, ask yourself, should the law ever require exit or voice rights? Should the law ever require that associations disclose to stakeholders ex ante what their exit or voice rights will be? What should be the default exit and voice rights for different kinds of associations? Acoustic separation is a simple and powerful concept developed by Meyer Dan Cohen in a Harvard Law Review article, which helps distinguish between two sorts of legal rules: conduct rules, which are addressed to the general public and are designed to guide the public's behavior, and decision rules, which are directed to officials who are then tasked with applying the conduct rules. When these two rules diverge, the law tries to maintain an acoustic separation between what the general public hears and what the public official hears. For example, criminal law says to the public it's a crime to commit murder, but it says to the jury it's a crime to commit murder if there is proof beyond a reasonable doubt. Systems with acoustic separation can help accommodate competing social values, but they raise important problems of implementation and legitimacy. Implementation problems arise when the messages leak. For example, when potential murderers learn that they can avoid punishment if they deny prosecutors the requisite level of proof. Legitimacy problems can arise if the public realizes that the decision rules diverge substantially from the conduct rules. Acoustic separation occurs in a variety of contexts. McDonald's, for example, has discounted coffee for customers 55 and over. But I think intentionally they poorly advertise this fact by having the discount rule for its staff and another rule advertised as the price above the counter, it might hope to have the news leak only to those older customers who really care about getting a slightly cheaper price. The acoustic separation tool is useful because it alerts you to the fact that the law can speak simultaneously and manage to say different things to different audiences. Homework. Can you think of other circumstances where regulations do or should try to implement acoustic separation? Can you think of a circumstance where the effort to maintain different messages to different audiences has failed? The most cited article in all of legal academics was written by Nobel Prize-winning economist Ronald Coase. The article is called "The Problem of Social Cost," and it includes what has become to be known as the Coase theorem. The Coase theorem holds that in a world without transaction costs, the choice of legal rules does not affect efficiency, because private parties would always bargain their way to optimal behavior. Coase's famous example concerns the potential of railroad train sparks to cause fires to adjoining farmland. In the absence of bargaining, one would expect railroads to take more precaution, for example, by adding spark guards to their trains, if the law held railroads responsible for any fire damage losses to farmers' crops. In contrast, in the absence of bargaining, one would expect farmers to take more precaution, for example, by planting their crops further away from the railroad tracks, if the law held that the farmers had to bear any fire damage losses that occurred to their own crops. Before Coase, lawmakers believed that in deciding whether to hold railroads liable for crop damages, the law would be influencing the amount of precaution taken by both railroads and by farmers. But by exploring a frictionless world of contracting, where potential contractors without cost agree to all mutually beneficial transactions, Coase deduced that the law need not influence precaution taking. In a world without transaction costs, the parties will have a mutual incentive to agree to have each expend the efficient level of precaution. In a world without transaction costs, if the law holds railroads strictly liable for all fire losses, the railroad will pay farmers to take the appropriate amount of precaution. In contrast, if the law holds railroads blameless for any crop losses, then Coasean contracting will lead farmers to pay the railroad to take the efficient level of precaution. In a world of costless contracting, the choice among different legal standards for liability will not impact the levels of precaution taken by the railroads and by farmers. The legal standards will only impact the distribution of wealth, as the background legal rules will often determine who pays whom. The theorem holds that in the absence of transaction costs, the assignment of legal rights will not impact the ultimate allocation of rights. This is sometimes referred to as the allocational invariance result. Because rights flow to their highest use, the Coase theorem also holds that in the absence of transaction costs, the rights will be efficiently allocated. But again, the assignment of rights will impact the distribution of income, because if the most efficient owner is not initially assigned a right, he or she will have to pay for it. A huge and contested body of literature endlessly debates the circumstances under which the Coase theorem predictions hold. Few scholars think that the conditions of costless contracting ever obtain. But just as the assumption of frictionless motion has proven to be a useful construct for physics, the assumption of frictionless contracting allowed Coase to analyze the effect of unimpeded bargaining in the shadow of the law. With unimpeded bargaining, different legal rules will not influence allocative efficiency. They'll only have distributional effects. The Coase theorem has also interesting implications for contract law. Oliver Wendell Holmes Jr. famously reoriented contract law toward a dyadic conception of contractual duties. For Holmes, a contractual promise was not a sacred duty that simply had to be performed. Rather, a contractual promise was merely the duty either to perform or pay compensatory damages. But the Coase theorem invites a triadic conception of promise. Following Coase, we might see a promise as a duty to perform, pay damages, or renegotiate your way out of performance. Imagine, for example, that Holmes promised to paint Coase's picture for $1,000 in a bizarre jurisdiction that imposes property rule-like damages that are 20 times the contract price. If Calabresi comes along and offers Coase $10,000 to paint Calabresi's picture, instead, the prospect of huge damages would normally deter Coase from breaching the initial contract. But the Coase theorem suggests that Coase will have an incentive to approach Holmes and try to buy his way out of the Holmesian contract. The Coase theorem suggests that we don't have to worry about too few breaches when damages are high, because promisers will bribe their way out of having to perform an inefficient promise. Can you see how a similar argument means we don't have to worry about too many breaches when damages are low? The Coase theorem has even stronger implications with regard to the law's choice among different possible default rules. For example, in most jurisdictions, the default rule is at-will employment. This means that in the absence of contractual provisions to the contrary, an employer can fire an employee for good, bad, or no reason. Some commentators have proposed that a better default rule would be a just cause employment condition. Under just cause default, an employer would promise not to fire an employee unless the employer had just cause. As applied to the choice among default rules, the Coase theorem suggests that the law will impact neither allocative efficiency nor the distribution of wealth. In a world with costless contracting, the employer and employee will contract for the efficient level of protection that maximizes their joint gains, regardless of the default rule. And regardless of the default rule, the parties will contract for the same salary. Guido Calabresi, and possibly the most important tort book ever written, The Costs of Accidents, argued that the optimal tort liability regime is one that minimizes the sum of the cost of accidents and the sum of avoiding accidents, including the administrative costs of the tort system. Calabresi concluded that such a regime will sometimes call for assigning tort liability to the least cost avoider. The least cost avoider sometimes is also called the cheapest cost avoider. It's the party who is best able to minimize these costs. So imagine there's a factory that is polluting and causing damage to nearby neighbors. If it's cheaper for the factory to install a scrubber or move than it is for the neighbors to move or acclimatize to the noxious fumes, then the factory is the least cost avoider. This concept can be applied across a host of areas in the law where a potentially avoidable harm has occurred. A retailer drafts an offer, mistakenly leaving off a zero from the price of an iPad. When that happens, courts might ask, are there contexts where the offeree is the least cost avoider instead of the offeror who placed the mistaken ad. Or imagine that a factory uses an employment agency to hire a new worker, only to find 6 months later that the worker had undocumented residency status. Again, the court applying the least cost avoider concept might ask, who was better placed to avoid this mistake, the agency or the employer? What is the relationship between least cost avoider analysis and the claims of the Coase theorem? Or can you think of other circumstances where the concept could be used? P.S. The pedant in me wants to point out that when there are only two parties involved, it would be more appropriate to refer to one as the lesser cost avoider. This is because least is a superlative adjective which should only be used when comparing three or more things, but no one says that. If you ask, how can you find the top of a hill? Most people answer by saying you should look for the highest point or keep walking upward until there's nowhere else to go. But an economist might say, look for the place that's flat. At least with regard to smooth and convex curves, the maximum point will be at that place where the slope of the curve is zero. This simple attribute of hills lies behind the idea of marginalism in economics. To maximize or minimize some outcome with respect to some underlying input or variable means that you're going to want to look at the margin, at the marginal effect that changing the input has on the outcome. Assessing the marginal effects is also the core idea when you want to maximize or minimize the difference between two curves. Again, assuming smoothness and certain convexity. Thus, monopolists in choosing the profit-maximizing output will classically want to produce the quantity at which the marginal revenue, the revenue from the last unit produced, equals the marginal cost, the incremental cost of producing that last unit. Consider these two graphs. In the left-hand graph, marginal benefit, MB, of one or more unit of some activity Q decreases as Q goes up, as it might if Q was the time spent studying for an exam. As you study more and more, the marginal benefit of the last hour decreases, while the marginal cost of studying or of some activity goes up. It becomes more tiresome. The last hour after spending 8 hours becomes more annoying. And the total benefit is the area between these two curves. Up to this point Q star, the total benefit curve is increasing because up to that point the marginal benefit is at every point is above the marginal cost. But after Q star, the total benefit, is decreasing because beyond that point the marginal cost is above the marginal benefit. A law student might stop studying when you think the annoyance of the next minute outweighs the incremental expected increase in the exam score that minute might provide. That's the essence of marginalism, that you maximize things at the flat point, or that total benefit will be maximized when the marginal benefit is equal to the marginal cost. This is the point where the slope of the total benefit curve is zero. Thinking on the margin has huge payoffs for both law and regulation. Imagine that the BP oil well has just dumped 1 billion barrels of oil into the Chesapeake Bay. The government can clean up the spilled oil for a cost of $100 million and thereby avert a social cost of $500 million. Should the government undertake the cleanup or force BP oil to do so? Most people would think this is a no-brainer. The benefits are 5 times greater than the costs. So doing the cleanup clearly passes cost-benefit analysis. But an economist would want to ask whether the last bit of cleanup was cost-effective. The economist would want to think on the margin. It's possible that for merely $20 million, $450 million of the pollution social costs can be averted. That means that spending the final $80 million only saves an additional $50 million in social costs. On the margin, society might be better off not cleaning up the last bit of pollution. But BP might still be liable for $500 million. Can you see why optimal deterrence might still be $500 million if the government pays for the cleanup? Or consider this. When I was on a Disney cruise with my kids, I accidentally dropped a tissue overboard. Should we turn the boat around and search for the quickly disintegrating tissue? Thinking on the margin also suggests an improvement in the famous learned hand rule that was first announced by Judge Hand in United States versus Carroll Towing, a case in which a barge broke free of its mooring and damaged other vessels. Judge Hand had the temerity in this startling opinion to propose a formula to assess whether liability should be found. Now, I've already mentioned this formula before in the lecture on risk and uncertainty, but this is how Judge Hand's opinion described the formula with slightly different letters than is used today. Judge Hand said, "Since there are occasions when every vessel will break from her moorings, and since, if she does, she becomes a menace to those about her, the owner's duty, as in other similar situations, to provide against resulting injuries is a function of 3 variables: the probability that she will break away, the gravity of the resulting loss, injury if she does, and the burden of adequate precautions." Possibly it serves to bring the notion into relief to state it in algebraic terms. And again, I'm still reading from Learned Hand's opinion. If the probability be called P, the injury L, and the burden B, liability depends upon whether B is less than L multiplied by P. That is, i.e., whether B is less than PL. Unquote. Hand's reasoning has great power for all or nothing precautions that can completely eliminate the probability of loss. But a more general version of the Hand formula would think about the marginal burden of precaution, for example, of tying down the barge with an additional cable, and the marginal impact of that precaution in reducing the probability of loss. Restated in marginal terms, the law should ask for a potential defendant to take precaution, should call upon potential defendants to take precaution up to the point at which the marginal benefit is equal to the marginal reduction in probability times the loss. Try to think, and now as homework, try to think of another legal rule or regulation where the law should turn on a consideration of marginal cost and marginal benefits. When you read a decision, take a second to ask yourself whether the case arose during the time of a military or economic crisis. If yes, you should think about whether the exigencies might have influenced the court's decision. The Supreme Court's equal protection scrutiny of the Japanese internment camps in Korematsu versus the United States might have been more searching if the country were not at war. To make an argument that a legal decision is influenced by an economic or military upheaval is usually only the starting point of analysis. But even sophomoric insights can be impressive when you're just a freshman. Causation can at times run in the other direction. The infamous Dred Scott case is an example where a decision of the Supreme Court led to a panic, the Panic of 1857. Immediately after the opinion was announced by the Supreme Court, the bonds of the East-West railroads collapsed as markets feared that the entire West would be engulfed in the bleeding Kansas violence. To make it easier for you to reflect on the timing of decisions in U.S. history, I've created a handy list of 15 economic panics and recessions, as well as a longer list of our military conflicts. The lists are incomplete, focusing on the crises that were either larger or possibly more likely to impact lawmaking. Most law students are already familiar with when we were engaged in war, but many are oblivious to the timing of economic crises. You need only look around to what has happened in the aftermath of the home mortgage crisis to see how both statutes and the common law have been affected. I recommend memorizing the dates of the 15 panics listed here. It only takes a few minutes, and it makes for great cocktail party conversation. Notice how regular the panics were in the 19th century, coming in something close to 20-year cycles: 1807, 1819, 37, 57, 73, 93. You might also note that the economic crises reduced the chance of re-election, as Martin Van Ruin can attest. He took office just before the Panic of 1837, and his presidency never recovered. So, as homework, can you identify the dates of World War I, World War II, the Korean War, Vietnam War, and the First and Second Iraqi wars? Can you identify who was president in 1851? I think it's Millard Fillmore. Law and economics has provided fairly well worked out mathematical tools for analyzing risk. A simple example is the learned hand formula, which says that a duty of care is owed in tort law if and only if P times L is greater than C, where P is the probability of loss, L is the size of the loss, and C is the cost of taking care. This quantified probability of loss, P, is a classic measure of risk. The formula is named after Judge Learned Hand, who's got to have one of the coolest bench names. He's kind of the Elon Musk of judging. And his brother, Augustus Hand, was also a judge. At Yale, we have a running group called the Learned Feet that I run with. But back to risk. When things are at risk in this kind of measurable sense, risk-averse people will be willing to pay for insurance to mitigate or eliminate the risk. Economists have developed quantitative measures of risk aversion, as well as fairly developed theories of the two primary obstacles to insurance markets: adverse selection and moral hazard. With adverse selection, people who know themselves to have higher risks of claiming are more likely to buy insurance. With moral hazard, people who have bought insurance are less likely to take care and hence increase the probability of claiming on their insurance. But in contrast to the concept of risk with known measurable probabilities, Frank Knight has emphasized the distinct concept of uncertainty. Knightian uncertainty is a kind of risk that is immeasurable, not possible to calculate. Knight said, "Uncertainty must be taken in a sense radically distinct from the familiar notion of risk, from which it has never been properly separated. The essential fact is that risk means in some cases a quantity susceptible of measurement, while at other times it is something distinctly not of this character, and there are far-reaching and crucial differences in the bearings of the phenomena depending on which of the two is really present and operating." Unquote. It's now a standard move in law whenever someone draws implications from quantitative models of risks, such as the learned hand formula, to ask whether the law should also be concerned with uncertainty as well. Indeed, the precautionary principle can be thought of as an approach to uncertainty management with regard to environmental safety issues. The principle, which has been adopted in the EU and to some extent in the United States, is a kind of better to be safe than sorry idea. The principle comes in many forms, but it resonates with the idea of uncertainty because it tends to mandate taking precaution when some cause or effect of safety regulation is not well estimated. Law and economics scholars tend to critique and limit the normative implications of uncertainty and the precautionary principle. Cass Sunstein, for example, has argued that the precautionary principle taken to its extreme would be stultifying. We could never have allowed Wi-Fi or laptops or cell phones since we can't be 100% sure that it will not cause some negative health effects. The distinction between risk and uncertainty might also be at play with the legal concept of unforeseeability, which will play a role in the torts and contracts doctrines that you'll study in your first year. In two cases that are so well known that like Madonna and Beyonce, they often go by a single name, Palsgraf and Baxendale. These cases cut off liability for unforeseeable risks. But there's a sense that this unforeseeability, what is not capable of being foreseen, may still give rise to a disquiet that Knight would have thought of when he wrote about uncertainty. And finally, for members of the CrossFit cult, you might relate the risk and uncertainty distinction to Glassman's insistence on a difference between the unknown and the unknowable. One of the most important philosophical tools of the last century is John Rawls' Veil of Ignorance, which asks how a person would want to organize society if the person were placed in what Rawls called the original position. But behind the veil of ignorance, this person would not know, according to Rawls, quote, his place in society, his class position or social status, nor does he know his fortune in the distribution of natural assets and abilities, his intelligence and strength, and the like, nor, I'll add, his or her gender. Rawls argued that behind the veil of ignorance, people would agree to a much more egalitarian distribution of wealth. In particular, Rawls claimed that those in the original position would all prefer a maximin strategy, which would maximize the prospects of the least well-off person in society. His difference principle permits inequalities in the distribution of goods only if those inequalities benefit the worst-off members of society. Rawls's particular answers to the thought experiment have been criticized. For example, behind the veil of ignorance, if you had a choice between a distribution where everyone had $2 of wealth and another distribution where everyone had $1 million except for one person who had $1, which would you decide? Which would you prefer? I believe Rawls would argue that people would prefer the distribution where everyone had $2. Everyone received $2. Harold Dempsey used an example like this to counter, though, that people behind the veil of ignorance might not be so risk-averse. In a world with 6 billion people, I might, from the original position, behind the veil of ignorance, take the chance of receiving only $1. But the idea that decision makers behind the veil of ignorance would make better and less biased choices has several real-world applications. Claudia Golden and Cecilia Rouse have shown that orchestras that auditioned musicians behind a screen started hiring substantially higher proportions of women. A literal screen of ignorance reduced bias. A crucial implication of Rawls is that having a decision maker know less can perversely improve decision making. Akhil Amar has argued that lawmakers today are somewhat analogously behind the veil with regard to regulation of the distant future. It would be difficult to get bipartisan consensus with regard to whether the tenure of Supreme Court justices should be limited today, because it's clear whether liberal or conservative justices are most likely to be affected by any mandatory retirement rule that took effect now. But it's close to impossible to predict the political impact of limiting judicial tenure 50 years from now, so it might be possible to find more bipartisan consensus for rules that only take effect in the future. The 22nd Amendment limiting presidents to serving 2 terms was easier to pass because it did, quote, not apply to any person holding the office of president when this article was proposed by the Congress, unquote. Adrian Vermeule has identified a host of constitutional and statutory veil of ignorance rules, which he defines as rules that suppress self-interested behavior on the part of decision makers by subjecting the decision makers to uncertainty about the distribution of benefits and burdens that will result from a decision. The take-home here is that Rawls's veil is not just a powerful thought experiment, it can lead to new ways to get better legal rules enacted. Now, as homework, can you identify provisions of the Constitution or statutes that might qualify as veil of ignorance rules? One of the most important advances in social science analysis of law has been the effort of psychologists and behavioral economists in identifying systematic deviations from the neoclassical economic assumptions that individuals act rationally to maximize their utility. Rigorous randomized experiments have produced evidence of a host of circumstances in which people display limited rationality, limited willpower, and limited self-interest. To be well educated today, you need to be comfortable recognizing the possibility of overconfidence, self-serving biases, hindsight biases, anchoring bias, framing and endowment effects. This is a large and important topic. For a host of applications of these concepts to law, I recommend that you read 2 of the most cited articles of the last several decades. One is by Russell Korobkin and Tom Ulen, and it's called Law and Behavioral Science. And the second is by Christine Joles, Cass Sunstein, and Nobel Prize winner Richard Thaler, and it's called A Behavioral Approach to Law and Economics. The fact that these 2 articles on behavioral economics make the most cited lists regularly is one sign of how important behavioralism is to current scholarship. And instead of lecturing to introduce these concepts, I'm going to use, or as lawyers would say, incorporate by reference, a delightfully nerdy song that musically defines the most famous behavioral biases. The song was created by Bradley Ray, a high school teacher in Maryland, as a study aid for the students preparing for their AP psychology exam.
I'm biased because I knew it all along. Hindsight bias, I knew it all along. I'm biased because I put you in a category which you may or may not belong. Representativeness bias, don't stereotype this song. I'm biased because of a small detail that throws off the big picture of the thing. Anchoring bias, see the forest for the trees. I'm biased toward the first example that comes to mind. Availability bias to the first thing that comes to mind. Oh, bias, don't let bias into your mind. Bias, don't try this, it'll influence your thinking and memories. Don't mess with these, but you're guilty of distorted thinking. Cognitive bias, your mind becomes blinded. Decisions and problems, you've been forced to solve them wrongly. I'm biased because I'll only listen to what I agree with. Confirmation bias, you're never-minded if you are this. I'm biased because I take credit for success, but no blame for failure. Self-serving bias, my success and your failure. I'm biased when I remember things the way I would have expected them to be. Expectancy bias, false memories are shaped by these. I'm biased because I think my opinion now was my opinion then. Self-consistency bias, but you felt different way back when. Oh, bias, don't let bias into your mind. Bias, don't try this, it'll influence your thinking and memories. Don't mess with these, you're guilty of distorted thinking. Cognitive bias, man becomes blinded. Decisions and problems, you've been forced to solve them wrongly.
And then homework. How could an appreciation of these biases support a particular regulation of home mortgages? Conjure an example where the biases might support repealing an existing law.